The Logan Paul court case just took a bad turn.
Logan Paul is refunding people he scammed if they promise to stop suing him for the vastly larger amount he may owe.
We're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. As Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it.
I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me.
Is what Logan is actually offering to refund, on the condition, though, that all of the people who spent the last year suing him for the larger damages drop their case. So that's a refund of only 12% to drop 100% of the case that, as far as I can tell,
Logan Paul is offering refunds to people affected by CryptoZoo. At first, that sounds like good news, until you look a little closer. Because according to critics, there's a catch. The people receiving those refunds may have to give up something much bigger in return. And that's why this story is exploding all over again. Right now, Logan Paul and CoffeeZilla are locked in a legal battle that keeps getting messier every week. What started as a controversy surrounding CryptoZoo has slowly turned into a courtroom fight over transparency, accountability, and one question that nobody seems able to ignore.
In case the two parties are currently fighting over whether Logan Paul can mark his entire deposition as confidential. And in the last couple of videos that I did on this topic, I talked about how this is actually highly unusual to ask for an entire deposition to be marked confidential. And I talked about how Logan Paul's arguments for why it should be marked confidential are actually really...
What exactly is Logan Paul trying so hard to keep hidden? Over the last few weeks, Logan's legal team has been pushing aggressively to keep his deposition confidential. If you don't know what a deposition is, it's basically a formal interview under oath. No edits, no retakes, no carefully crafted YouTube response, just questions and answers. CoffeeZilla's legal team gets to sit down with Logan and ask direct questions about CryptoZoo and everything connected to it. That's why people immediately became suspicious when Logan's team started fighting so hard to keep the deposition out of public view.
Problem. He doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as...
Because usually, if someone feels confident about what's inside a deposition, they don't spend this much energy trying to seal it. And that's where things started getting interesting. According to legal commentators following the case, Logan's arguments for confidentiality aren't landing particularly well.
That in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like forceful or aggressive in your tactics, but I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to the opposition, but nevertheless, it should be able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already...
Some people believe the deeper this case goes, the worse it looks for him, because courts generally don't allow documents to be hidden just because they might be embarrassing. There usually has to be a specific reason: sensitive personal information, private records, security concerns, something concrete. And according to CoffeeZilla's side, Logan hasn't really shown that. Instead, critics argue that his team is asking for broad secrecy without providing the kind of justification judges normally expect. That's a problem, because American courts generally start from the opposite position. Transparency comes first. Secrecy has to be earned. Logan's team eventually presented 4 major arguments for why the deposition should remain confidential. On paper, that sounds reasonable. In reality, that's where things started falling apart. The first argument was that CoffeeZilla supposedly couldn't be trusted with the deposition because he might share it with other lawyers, investigators, or people connected to related cases. At first glance, that sounds serious, until you realize there's a major problem.
For Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. You know, where both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to CoffeeZilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition confidential.
Sharing legally obtained, non-confidential information with attorneys or investigators generally isn't some shocking violation. It's often completely normal. That's why critics immediately started questioning the argument. If the information isn't confidential in the first place, then why would sharing it automatically become a problem? And that wasn't the only issue. Legal analysts pointed out something else that looked strange. Logan's team repeatedly referenced legal cases that were supposedly supporting their position, but according to people following the filings closely, some of those same cases seemed to say the exact opposite. One case in particular kept coming up. The ruling essentially reinforced a pretty simple principle. Court records are generally supposed to remain public unless there's a strong reason to hide them, not the other way around. And that's where the conversation started shifting. Instead of asking whether CoffeeZilla should have access to the deposition, people started asking a different question. Why is Logan fighting this hard to keep it private? Because every new filing seemed to create more curiosity, not less. Then came the second argument. Logan's side suggested that CoffeeZilla had previously shared information with federal investigators.
Tries to suggest that the case law CoffeeZilla is citing to says it's actually a more lenient standard than what CoffeeZilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote-unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoa Lee v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would naturally highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in two legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be sealed. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should...
Again, that sounds dramatic, but legally, it wasn't the devastating point some people expected it to be. Courts don't typically seal records simply because information might reach law enforcement. In fact, if somebody legally obtains information and decides to provide it to investigators, that's usually not enough by itself to justify secrecy. So once again, critics felt the argument wasn't really solving the core problem. It wasn't explaining why the deposition itself deserved protection, and that's the issue Logan's team kept running into. Every argument seemed to circle around CoffeeZilla's behavior, but very few arguments address the actual legal standard required to seal the deposition. Eventually, observers started noticing a pattern. The filings contained a lot of claims, a lot of accusations, a lot of courtroom back and forth, but not much that directly answered the biggest question. What specific part of the deposition is so sensitive that the public shouldn't see it? And the longer that question remained unanswered, the more attention the case attracted, because internet audiences are predictable. The harder someone tries to hide something, the more people want to know what's inside. And that's exactly what started happening here. Every filing generated new discussions. If you are watching till now, make sure to subscribe for daily content like this. Now let's continue. Every update sparked new theories. Every attempt to seal the deposition seemed to create even more public interest. Then things got even more complicated because Logan's legal team introduced another argument involving a protective order already in place during the lawsuit. They claimed CoffeeZilla had violated.
Not only is this understanding of this issue pretty common across the board in the United States, but the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And you know, I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoa Lee v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because this information was actually sensitive in any way. It's just the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is Law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also Civics 101. The Constitution's first 3 words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we, the people, are not meant to be bystanders, the default expectation is transparency. That what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough,
But once people started examining the actual language of that order, critics argued that it didn't appear to prohibit the type of information sharing being discussed, which created another problem. If the protective order wasn't actually being violated, then the argument suddenly became much weaker, and at this point, even neutral observers were starting to notice something. The legal battle was becoming less about proving confidentiality, and more about defending the request to keep everything hidden in the first place.
I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Findeisen and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case, and conduct which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about CoffeeZilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, you know, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are getting the idea that the court expressed this concern about the sharing of information. Specifically, Paul's lawyers attach a very small bit of transcript from this hearing to show this. It's really not enough to get full context on what exactly was being said, but we can basically put together more or less the main gist of it. And the thing is, now that I've seen at least this much of what the judge said here, Based on how much I can put together,
That's never a great position to be in, especially when public curiosity is growing by the day. Because while lawyers continued arguing over motions, filings, and procedural disputes, most viewers were focused on one thing: the deposition, the document at the center of everything. The document Logan Paul seemingly didn't want people to see, and naturally, people started wondering why. Then came what might be the most controversial part of the entire dispute: the judge transcript argument.
problem for them, because that would mean that they are twisting the judge's words to the judge. Let's take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about CoffeeZilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, "So I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case. He's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to subject themselves to deposition, I'm concerned that that could be prejudicial to them. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. And the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? I'm worried. I do not want to prejudice the parties. I need to hear from the parties as to how to address these issues. It's separate from the motions in front of us. I'd like to start with the plaintiff." So it sounds like what the judge is really saying here is, we have these two cases where one person is a party in both of them, that's Logan Paul, and then you otherwise have other people who can be affected in one case by something in another case that they're not even involved in. And so rightly, the judge is worried that there are things that can happen here that could lead to an unfair prejudice to one or another side, and if these parties start to engage in discovery.
And according to legal commentators following the case, this is where things started getting risky, because courts take one thing very seriously: accuracy, especially when lawyers start quoting judges. At one point, Logan's legal team referenced comments made by the judge during an earlier hearing.
Logan Paul is refunding people he scammed if they promise to stop suing him for the vastly larger amount he may owe them. And honestly, I'm conflicted, because on the one hand, victims getting money is always great, and I'm proud that our investigation led to some real-world consequences. But I can't pretend that things are fixed or fine for people who entrusted me with their story when that's just not true. So here's the real, more complicated story in 3 parts: the refund offer, the zoo tokens, the lawsuit, starting with the most important part. And if you get one thing from this story, this should be it. These are the estimated damages in CryptoZoo, $18.5 million, which comes from a combination of ZooCoin and NFT sales. And then this, much smaller percentage of that pie, is what Logan is actually offering to refund, on the condition, though, that all of the people who spent the last year suing him for the larger damages drop their case. So that's a refund of only 12% to drop 100% of the case. That, as far as
The filing made it sound like the judge had major concerns about CoffeeZilla sharing information connected to the CryptoZoo class action lawsuit. If true, that would obviously strengthen Logan's position. The problem is that people started looking for those concerns inside the judge's written orders, and they couldn't really find them. That immediately raised questions, because if the judge was genuinely worried about something that serious, why wasn't it clearly reflected in the written ruling? Eventually, the answer appeared to come from a hearing transcript. Even then, critics weren't convinced. According to legal analysts, Logan's filing only included a very small portion of the discussion, not the entire conversation, not the full context, just a short section, and that's where the controversy exploded, because context matters a lot, especially in court. When people reviewed the surrounding discussion, many felt the judge wasn't necessarily accusing CoffeeZilla of wrongdoing at all. Instead, concern seemed much broader. The judge appeared to be discussing the complications that happen when 2 related lawsuits are unfolding at the same time, which is a very different issue. One interpretation suggests CoffeeZilla is behaving improperly. The other suggests, I'm concerned both sides could gain advantages between overlapping cases. Those are not the same thing.
Remember, the judge started out here in this hearing transcript talking about CoffeeZilla's motion to transfer the case. If we look back, in that motion, CoffeeZilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish CoffeeZilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from CoffeeZilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order." What that means is the judge is actually recognizing that the protective order can't necessarily stop CoffeeZilla from sharing non-confidential information with the class plaintiffs. And then, importantly, the judge immediately also says, and the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? Again, he's saying, how could he not use that in that case? That means he's once again acknowledging, I know I can't stop Logan Paul from using discovery over there after he gets it over here. And so what we can piece together is that the judge here isn't saying, hey, CoffeeZilla, you're not allowed to share information with the class plaintiffs at all. And to be clear, that is actually what Logan Paul is trying to suggest in this current argument over his deposition. But rather, what it sounds like the judge is actually saying here is, I'm worried about all of this just turning into a huge mess where both sides start to abuse the discovery process across the board to get an unfair one-up on each other.
And that distinction became incredibly important because if critics are correct, then Logan's filing may have framed the judge's comments in a way that made them sound more favorable than they actually were. That's the kind of thing courts don't usually appreciate. Judges expect their statements to be represented accurately, not selectively, not creatively, accurately. And while nobody can know exactly how the judge views the situation right now, legal observers started pointing out that credibility matters a lot. Once a court begins questioning a party's credibility, every future argument becomes harder to sell. That's why this part of the case received so much attention. It wasn't just another filing. It was becoming a debate about trust in the arguments, trust in the evidence, and trust in the way the case was being presented. Meanwhile, another issue was quietly gaining momentum, the refund program. Because while lawyers argued over depositions and court records, CryptoZoo investors were focused on something much more personal, their money. For years, many people involved in CryptoZoo have argued that they never received meaningful compensation for what happened. Then Logan announced a refund initiative. First, it sounded like a major step forward. Finally, some accountability. But once details started emerging, criticism followed almost immediately.
Has released his third response video to CoffeeZilla and the CryptoZoo community.
CoffeeZilla is not a criminal. I called him. I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially, you're going to be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, CoffeeZilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that.
Because according to critics, the refund offer only covered a small portion of the damages being discussed in ongoing litigation. Most people want victims compensated. The issue was whether the offer truly matched the scale of the losses being alleged. Critics argued that it didn't. Supporters argued that some money is better than no money. And suddenly the conversation became much more complicated because both sides could make reasonable points. Whether it's CryptoZoo, lawsuits, refunds, public apologies, or damage control, people keep asking the same question because this isn't even the first time Logan has been accused of attaching himself to something purely because he saw an opportunity. His latest controversy involves one of the biggest manga franchises on the planet, and somehow Logan managed to upset an entire community after people accused him of buying into it without even understanding what he purchased. You can watch that video next on our channel.